I believe that STAR has some individuals here who are going to be providing some testimony, and I will yield to Morgan.
Okay. Okay. Good morning, task force members. My name is Morgan Lamandre, and I am the Vice President of Survivor Services at STAR. That's essentially a fancy title. That means I oversee any direct services provided to sexual assault survivors. And I want to explain a little bit about STAR and what we do, but we recently have this fancy little video that explains all of that for you in 5 minutes, and it's pretty amazing. So what we're going to do is play a little video for you. Do I just click? And now I don't know what I did. Not tech savvy at all. I'm just trying to get to the second one to play the video. Second slide.
Yeah.
It should be me. I have it on the jump drive. It is on my Mac. Can we somehow use my Mac?
No. Can't hook your equipment into ours.
We'll go to the second slide. I have it on a... Okay. While we are having technical difficulties, I have the video, but we're not able to use our equipment, so I apologize. But we can just jump right into sort of our services, and maybe... I have a jump drive that has the video on Okay. We'll come back to that. But just getting right in, I do have some students and some other program staff in our legal program, if they could come up and introduce themselves. Essentially, our legal representation services, we have to where we provide legal representation to survivors 13 and older. And in our legal program, we have some students, and you guys can come up. You guys can come up and introduce yourselves. Sorry, this whole video thing just messed us up completely.
My name is Brittany Wagnon, and I am a student attorney at STAR. What that means is I'm participating in a clinic at LSU Law where I'm a 3L, and I've been sworn in under Rule 20 of the Louisiana Supreme Court rules.
Hello, my name is Sharita McNeil. I'm a staff attorney at STAR. I recently started, so I'm just learning all the different areas that the education elements contain and all that it has to offer.
Good morning, committee members. My name is Jeffrey Wheeler. I'm a student attorney at STAR. I'm currently enrolled at LSU Law. I'm a third-year law student, and I've been working with STAR since the beginning of this school year. I've helped primarily with various different family law matters and matters involving high schools and Title IX.
Good morning. My name is Brittany Tossian. I currently attend Southern University Law Center as a 3L. I currently serve as the legal intern at STAR, and I assist in doing the research necessary for the student attorneys as well as Morgan to represent the survivors. I also currently serve as a volunteer phone advocate with STAR.
So right now, we have a partnership with the LSU Law Center in which we provide a clinic for the students to represent survivors of sexual assault. And in the types of representation we provide, we do education issues. So right now we're able to represent students in campus disciplinary hearings. We also provide services on family law matters where survivors, if they have conceived and they need child custody or parental rights termination because a child was conceived through rape, we do that. We have employment law issues that we deal with, victim rights, housing. There's various issues where we're able to represent survivors. If you guys want to come up and talk about, just sit up here. Sit up here. Here, Brittany. Sorry, we got a little messed up from not having our video. If you want to just briefly tell them about some of the things that you've been doing as a student attorney and who you've represented and the cases and all that you've kind of had.
As a student attorney at STAR, I've gotten to represent survivors directly, which is a unique experience that a lot of law students don't get. But some of the cases that we've been dealing with include a lot of, you can talk about like services or whatever. Okay. So basically, we talk to the survivor and see mostly what she needs, like what it's called survivor-centered services, right? So it needs to be something, whatever they want. We make sure that they're in control, and we look at, she mentioned family law, but also education remedies. So if there's any administrative remedies, we can do any accommodations, like if the assault happened on campus or with a student. Also housing, if maybe the assault happened at their apartment complex, we can negotiate with their landlord to maybe get out of their lease, or possibly if the perpetrator lives in the same complex, talking about compelling them to maybe evict the perpetrator. Also employment remedies under Title VII, it is sexual discrimination if to discriminate against someone who is a victim of rape. Bo?
So yeah, Jeffrey Wheeler to introduce before. What I would have been working on primarily at STAR, like I mentioned before, were different family law matters. But however, it should be noted that our family law services are very limited in scope, and they're very focused in what we do. Primarily what we do is we assist survivors in different child custody matters, especially whenever the attacker or the survivor is related to the other individual that the child custody matter might be related to. We also assist in matters where a child was conceived as a product of a sexual assault or rape, and they are looking to terminate any potential parental rights that the rapist or the assaulter may or may not have. So we assist in those matters. Furthermore, one matter that we've really kind of started to dive into recently is Title IX involving high schools. It's often perceived that whenever we talk about Title IX that we only talk about universities in the university setting, and the universities have come a long way in really incorporating that into their system. However, high schools are covered by Title IX, and they are just in the same way that any university has. However, we have found that many high schools aren't necessarily as up to date as our universities are, and many university students who are survivors or are victims don't necessarily know about their rights or any potential remedies they have, let alone much younger and potentially more vulnerable high school students. So in the scope of our services, we have been helping different high school students, or helping high schools that kind of don't necessarily know what remedies are available to them under Title IX. So we've assisted greatly in that area.
And just some things with working with survivors on college campuses that we have noticed. I think it's come up quite a few times that survivors who are assaulted on campus or even off campus, they don't know of the available academic accommodations that they have or can seek out. So what'll happen is they'll begin to get low grades, they'll drop out, they'll even maybe fail out, and then finally, after some time has gone by, they enroll back in school or even attempt to roll back in school, but there's no way to retroactively go back in and maybe get a different grade or retake a course without that course still being on their record with a low grade. That's not something that's currently outright available to them. Another thing is that although some of the investigators on college campuses have Title IX training, that training is actually not trauma-informed training. So victims are being re-victimized all over again. This process has been set up historically because not all survivors want to report to law enforcement, but even in reporting to college campuses, they're being re-victimized because survivors are not being met with trauma-informed services. Another thing is that we are finding problematic is that students are not being told the difference between responsible employees, confidential advisors, and persons with privileged communications on campus. Just because somebody is a confidential advisor on a college campus does not mean they have privileged communications, meaning that if they later do report to law enforcement, any communications they had with that confidential advisor who does not have privileged communications under the law, that person can be subpoenaed to testify in a criminal case, and there may be things that that survivor disclosed to the confidential advisor that was not meant to be subpoenaed or talked about. And I think that that's one thing that really needs to be addressed or looked at. Another thing is that the whole processes are still confusing as far as what all has to be done. Survivors, if they don't bring forth evidence on their own, if they're not asked questions specifically, they don't necessarily know what's important or what's not important. So essentially they're becoming their own prosecutors in these proceedings, and it's quite hard to know when you're not an attorney what evidence you need to bring forward or tell these investigators, who then decide whether or not something has enough evidence to move forward at a hearing. And one of the things that's also problematic about that is these investigators are determining by a preponderance of the evidence if the case should move forward to a hearing. That's the standard to find somebody responsible, not to move forward to an actual disciplinary hearing.
I think what might be illustrative and useful for this committee is for y'all to potentially walk us through some of the existing processes are, and then give some example as to how the process is not working for a victim going through the process. Because I appreciate the overview, but since we're about to get into the weeds and really dig into this issue, I think it's very important for y'all to say, well, listen, here's an example. Obviously, we don't want names or confidential information, but say, here's an example of how I went through the process. Here are some areas in which the process failed the victim, and here was the outcome. I think that'd be very useful.
Okay. So in one case that I represented a survivor, she initially reported to a campus program in which they actually filled out a report to the student disciplinary panel, or whatever, it may be called. And they actually wrote it for her in first person as if she had wrote it. She did not review this before it was actually submitted, because she had been at this program the entire day, was getting medical treatment, had to recount what happened to her. I think it was 4 times at least before this last time the report was submitted. When it was read back to her, she said, that sounds about right. That sounds about right. When later on, looking at this report, it doesn't even look like any misconduct or a crime was committed. That's because no one asked her in a trauma-informed way what happened. There were certain things that happened that she was ashamed to really get into details, but also because she didn't have any consensual sexual experience in her lifetime, she also did not have the terms that most of us who think college students would have when describing what happened. So, not to be vague, but I'm doing so on purpose. Then, once that report was made, it took a significant amount of time before anybody followed up with her. She then decided at that point she actually wanted to go to law enforcement to report. When she reported to law enforcement, she, with the impression that what was in that report to the Title IX people was what was the crime, She went to law enforcement only saying what was in that report, which, as I had previously said, there was no indication a crime was committed in that report. So they very, very quickly, concluded that there was no crime in that case, and everyone just thought, oh, there's a misunderstanding. She just does not understand what the law is. Well, that's because still, at that point, no one had asked her, to just tell us what your experience is. By the time she came to STAR, a lot of time had gone by. She had already been interviewed by investigators on campus. She was not asked clarifying details. Once she got to STAR, we did do a trauma-informed interview, and we found out what was on that paper and what was on that report was significantly different from what had occurred to her. And through that process, after, she essentially was her own advocate and was following up with them more than they were following up with her. They had yet to interview the accused student because they said, well, he reported, since this is an open criminal investigation, that, the defense attorney was refusing an interview with the Title IX investigators. I found out that the criminal investigation was closed, and that still months went by before they actually interviewed. And we were like, per Title IX guidance, you cannot continue to refuse to interview this person just because their defense attorney is saying that you do not have to, they're not going to come. You should move on without them. And they still waited, and finally they did interview. And once they interviewed, there was different inconsistencies in the accused student statement and all of the evidence. There was no follow-up on any of the statements that were said. There was a lot of things in her statement that actually proved what occurred. And then there was a lot of, once they interviewed the accused student's friends, there was things in there that there was no questioning. I'm not saying, oh, Title IX investigators need to be trained interrogators, but I could just very clearly see the inconsistencies, and nobody was even asking for anybody to explain what to elaborate on these inconsistencies. So then after a quite...
Just a bit of elaboration. Because obviously as an attorney, I've professionally dealt with people who are investigators on various criminal matters, and the issue is that, so what you're saying is that it wasn't necessarily they weren't interrogating, they weren't really asking questions or follow-up questions.
Correct.
They were saying, well, what happened on this date? Tell me your side of the story, and they weren't being asked questions on their inconsistencies. The person who was supposed to be a fact finder was not interested, in your opinion, in finding facts. They were interested in just writing down what someone told them and moving on to the next person.
Exactly. And it was very clearly just the difference between the accused student saying, oh, she called me first that night and she called me and said that she wanted to hang out, when clearly you could see from the text messages and the phone records that was actually not what occurred. And nobody questioned just something as basic as that. And there was little things like that just so clearly showed me, in my opinion, the lack of credibility of the accused student. So that's where I find, we weren't even getting into the interrogation thing. People were just not asking the questions to get, I think, to the root of what was occurring. After a significant amount of time, the investigators found that there was, basing off of the standard by a preponderance of the evidence, that no misconduct according to the policy had occurred. And at that point, there was the ability to do an appeal. We did an appeal, but we were essentially pointing out the lack of investigation in their appeal, as well as just some internal type of issues, but they wouldn't consider any of the lack of investigation in the appeal, because you can only appeal something that's in the record for the appeal. So because there was a lack of investigation, there was things not in the record, they wouldn't consider that for the appeal.
So what you're saying essentially is that unless the victim does her own independent investigation, unless the victim puts her investigation in the record, the victim basically is at the mercy of whether or not the original investigators did their job.
Right. And I will say in this case, the victim did do a lot of her own homework, but there's only so much you can do.
Right.
She could not question, and she could not do things that required there to be more of an investigation into the accused and his statements.
I guess, and I've never been through this process. In the current process, can the victim, I guess, for lack of a better word, subpoena witnesses and make people who were there come and testify?
No.
So essentially, other than the Title IX investigator investigating those individuals, there's no way for the victim to point out those inconsistencies or anything on the record.
No, and in fact, I mean, in this situation, that's why, in my opinion, or where I've seen in other institutions, there's a lower standard to get to the hearing. And once you're on a hearing panel, then maybe you can ask witnesses to come, but there still isn't a way to subpoena students or witnesses. And, you know, that's also a problematic issue too, particularly where there's sororities and fraternities who then turn their backs to their fellow, you know, sorority sisters who no longer want to get involved, and then they know who are good witnesses, and then no longer want to be part of the investigation. And then, you know, schools are like, we can't make them do anything. It gets problematic. It gets really problematic, and I just think that in this whole process, you know, the student did not return to this university. She did not, and it's easy to understand why. One other thing, though, that I actually forgot that I wanted to point out is that at the beginning of this, there was a no contact derivative that was issued on campus. It was issued after the student requested it be issued, and in the letter to the accused student saying there is to be no contact, although the letter was specifically addressed to the accused student, it said in the letter that there was to be no contact between both parties. So it essentially issued a no contact order against the victim, but the letter wasn't addressed to her, and it was just very unclear what the parameters are of that no contact order. And I would like to see something be designed to where obviously it's not going to be the same as a Louisiana protective order where it goes into the registry, but I would like to see a standard form we could come up with that is used by universities that really spell out who is prohibited from what type of contact, where, what, you know. And obviously the client that I had was not going to be contacting this offender, but by prohibiting her and issuing essentially a no contact order against her, it was saying that she did something wrong when she did not. And like I said, she wasn't going to be contacting this person whatsoever.
And just for clarification, Morgan, I think it would help people up here. That practice has largely been discontinued by law enforcement as far as whenever someone files a domestic violence complaint, automatically giving the accused a reciprocal charge. I think law enforcement across the nation has moved away from that because you're right, as seen as if someone's accused of something horrendous, if some guy's accused of mugging you, you don't get a no contact order against the person who accused the guy of mugging her. Because it's kind of ridiculous, and it does imply that on its face that by making the complaint, the person did something wrong as well.
Right. And then just to kind of look into it, the one that they issued, the letter was addressed to the accused student. If you didn't read very, very well within the fine print, you know, you wouldn't have even realized that she had the no contact order, which there was, once you reported to law enforcement, a controlled call, which is, you know, a one party call to try to get somebody to admit to something, was attempted, but we did have it to where she wasn't going to be penalized for that through law enforcement. And of course, the accused didn't answer the phone, but yeah, we had to also make arrangements that she not be penalized because of that call made by, you know, for the law enforcement investigation. There any questions about this process?
I would be interested in getting some testimony from your 3Ls as far as what their experience has been through the process, because as third-year law students, they're not that far removed from college. So it must be an interesting perspective to have been someone who was recently in college trying to help current college students navigate that process and how difficult that process could be.
And I will say, I think that they're coming in on students who are just wanting to report this. They haven't gone through the entire disciplinary process with a student, but the ones that I think you might want to talk about, just some of the students that have come in who very clearly tell us they are not interested in going through the campus route.
That'd be helpful.
So some of the students that we've had at the various different universities in the state have come forward, and to certain degrees they have interacted with university staff and have afterwards decided that it was not a process they wanted to be involved with at all. Many of these survivors and victims don't even want to go to law enforcement, so going to their university can be even more they can be even more reluctant to do that. Also, as I mentioned earlier, I hate to kind of shoehorn this in, but high schools are also having a lot of the same problems, especially when it comes to, and I can also say as a student, just students understanding their rights and their remedies under Title IX can be a big issue that we assist them with, especially with high school students. And one of the problems that we have found is that different organizations that have responsibilities under Title IX are not aware of their responsibilities, especially involving grades and different kind of proactive steps that different Title IX obligated individuals are obligated to take. But just to address Senator Morrell regarding universities in particular, we found that students have come forward, or rather they've come to us. We've discussed their options under Title IX, going through the university system, and by and large, they have, because of the rather difficult process, that process being that they have to really put forth their own investigation, that they can't make people show up, that sometimes administrators, although many universities here in the state have been very good, sometimes administrators aren't very helpful. They will come to different counselors and they'll disclose things, but then they find out later that those private discussions might be taken into account, or unfortunately end up going to defense attorneys representing assailants or attackers. So altogether, in our experience, the students that we have worked with, the current students who've come forward to STAR seeking assistance, have by and large been very, very hesitant to go to university officials and report anything at all.
Well, and as y'all are obviously in a town with multiple universities, do you feel like the fact, I am sure that across multiple universities the policies differ, and so how difficult is it for a victim if they're from, how difficult is it from y'all providing services to be able to navigate these very different systems that are at different universities?
Each university has their own. It can be a little bit more difficult, especially when it comes to tracking down exactly who Title IX coordinators and Title IX responsible individuals are. Some universities don't they have a designated Title IX person. However, that individual will often wear many different hats and have many different responsibilities, and you'll find that, oh, I'm the Title IX coordinator. I hate to use this language, but sort of an afterthought. In some cases, the duties for the coordinators are divvied up and kind of divided amongst different administrators. So it's, even though in theory there's supposed to be a Title IX, like every school is supposed to, okay, well, this person is a Title IX coordinator for this university, this person is a Title IX coordinator for this university. In theory, that sounds great, but often it's not, okay, you're the coordinator. It's, oh, you're A, B, C, D, and the Title IX coordinator. And so these individuals are busy with other things. This is not their primary focus. So depending on the university and what the university administration, the degree of, I guess, weight they've actually put onto this title, if they've decided that some universities, if I remember correctly, at different states have people who are almost the only thing they do is Title IX, or they concentrate on that very heavily. Whereas in other universities, it's like I said, I'm being a little redundant now, but it's one of many different things they do, and every university is different in that respect.
And that's kind of what I wanted to piggyback on, is the need. That's why I think this is so important, is because I'm from a different part of the state. So I'm not from the Southeast region. I'm from the Southwest region. And the policies differ across the state largely. And maybe not even the policy, but the awareness. So that's kind of a second step, is not only we need this uniform policy across the university system, but also an increased awareness of these policies and an increased notification to students. And not just maybe one flyer, not just in the handbook, but they need to be out and about, because not all students are aware And then another thing that we see is privacy. This is a huge issue, whether or not what they say is going to be kept private. And that's what we've said that already about. We don't know the difference between a responsible employee and a mandatory reporter versus who is actually a confidential communication. So that's a really big concern with survivors is privacy. If I tell someone, who are they going to tell? So that's something we would like to see addressed, is something, along the lines of who actually keeps these communications confidential, who has to report, where is this going to go, who's going to be subpoenaed, that kind of thing. Also, another thing is a lot of survivors aren't sure that they're going to be believed if they go and tell someone at the university, or if they go tell their Title IX coordinator. So that's another thing is across the state, a uniform attitude needs to be. I don't know if that's a possibility, but that's something that I would personally like to see, is an attitude of, we believe you.
And if I may, just very, very briefly, also, we speak a lot, and I know I've said this a few times about universities, but high schools are covered under this, and we have in our experience noticed that even though universities aren't really fully there yet, high schools are even further behind on these issues. High schools often don't have, the large, immense staffs that many universities have, especially our larger institutions. So you have double problems with high school administrators. This just being one other thing that they, one person, a counselor or maybe a vice principal, has that responsibility. And oftentimes we find, unfortunately, that we'll have instances where a student will report, and an administrator or a Title IX coordinator isn't aware of the proactive steps that they are required to take under Title IX in the ensuing guidance documents. And they don't take those proactive steps. And the students, 14, 15, 16-year-old students, certainly have no idea and are not privy to the different intricacies of Title IX and the various guidance documents that have been released afterwards. So these administrators at the high school level, there is absolutely zero form of sort of overall approach that they take to this. Every single high school is it completely depends on the knowledge of the administrator, whatever school board or principal is overseeing it, and however much they want to stress to whoever they designate as their Title IX coordinator, how important that school is actually going to take that. There is no uniform approach whatsoever. This is just kind of, we have seen in our experience for some high schools, just another thing that a guidance counselor or a vice principal ends up getting taken on, and they're not as educated as we would like them to be on these issues and really helping the students who have rights to different remedies.
And just one more thing about going back to sort of, I guess, across the campuses, programs have been set up to where you can seek services on campus. Some of these programs, they are saying they are advocates, they are sexual assault advocates. I know Ebony Tucker's here and probably could elaborate on certain things that LaFASA requires of the sexual assault centers that are accredited by LaFASA, but these so-called sexual assault centers that are on campuses are not held to any standards that LaFASA has, and I would say that some of those services could be subpar because there's no oversight into what these services look like. You could probably elaborate on like curriculum for advocates and what they must go through in order to become an advocate from a sexual assault center, but this is not being done on campus. So when people do report to those on campus services, they might not be told all of their rights, and later when survivors end up thinking regardless whether they were handled, they met the system in a certain way that it was not favorable, they're like, you know what though, that those programs that I received online, they have a conflict of interest, because why would they tell me all that I needed to know? Why wouldn't, they have a reason in their mind to not disclose all of their rights available. At least that's actually, I'm not saying that's in fact true. I'm saying that's the perception of survivors that we see, that they are being wronged by these on-campus support services, essentially because it's a way not to be held, the school won't be held accountable if they're not told all of their rights.
Sounds to me like part of what you're saying is that we have a lot of aren't even meeting the federal requirements.
This thing isn't working at all.
That's absolutely right. In my opinion, yes.
Oh, I think we're having a technical issue up here. My entire board is not working as far as actually pressing buttons, so that's problematic. Um, yeah, so the issue is if you want to speak, please raise your hand so I can identify you, just so we can keep track of who's speaking for the secretary, just so that. So if you have questions, normally I'd recognize you by pressing the board. Well, first you got to press your button. Make sure you press your button. Let's actually try that first right quick. Oh, there you, well, nope, still not working. All right, so just raise your hand and we'll identify you and you can speak. Miss Woodley? Yeah. We'll repeat your comments for us real quick. I'm sorry, I was tinkering with this.
Like you guys are currently exist.
That's correct. Many of the universities do not seem to even be aware of those policies and guidance that is put forth by the Department of Education. In fact, a lot of people will tell us that it doesn't apply to them because their college is maybe a smaller college, and that's not actually correct whatsoever. But it's interesting to hear the different perspectives of administrators that are on campuses.
And I can certainly attest that based on the work we did in our study commission last year, the amount of, to be polite, it was tremendously disturbing how naive, especially smaller public institutions are, that they think somehow the standards don't apply to them because there's a lack of financial initiatives or a lack of funding. And the reality is the federal government, the federal law under Title IX does not differentiate between what your resources are. And part of the challenge we had in that commission and we have here as well is that whatever we come up with has to be something that can work regardless of what your resources are. Because obviously when you're talking about these smaller institutions, as we found last year, one of the institutions that we met with, their Title IX coordinator was a coach of one of the sports teams. And to say that she had a lack of information as far as how Title IX work was being generous. And it was no fault of her own because basically one day they said, hey, you're the Title IX coordinator. And obviously that's problematic, but those smaller institutions, we have to create a policy that almost educates them in their implementation because they're never going to have the resources that a larger institution does to have a robust Title IX program. So part of the challenge we have going forward with this commission, and this task force in particular, is to create a policy that everyone can utilize, regardless whether or not they're LSU or they're Grambling or whether they're Delgado or Suno or whatever. It has to work for everybody, and that's going to be challenging.
Right. And one of the things that I'm pretty sure every university we've come in contact that has been difficult is that all students seem to always have like a student code of conduct that had sexual misconduct in those student code of conducts from the beginning. But then those code of conducts didn't meet the standards for Title IX. So then they implemented like another policy that was a Title IX policy or a sexual misconduct policy, but they didn't edit those student code of conduct policies that still also have indications of sexual misconduct. So then it looks like there's two policies, and one will say one thing, and this is the process, and this is who you report to, and this is how the investigation goes, and you meet with the first person who determines whatever, and then the misconduct policy says something else, and it's really confusing because which policy is it? Because I wanted to go through what the student code of conduct said for one of the things that I was dealing with a client, because to me that was actually more compliant with as far as the procedure that I wanted to see, but the policies were not what Title IX, all of the policies were not complete, which is probably why they had the student misconduct policy.
Well, and I can tell you from my perspective as someone who just 1,000 miles up, what's very frustrating is that you'll talk to a university and say, what's your policy on cheating? And they will have a robust 4 or 5 different layer investigation regarding a cheating complaint where there's an appeals process. Here's how we investigate. Here's the strong criteria, and here you're out. And then you'll ask them, what's your policy on sexual assault? And it is this kind of ambiguous mess. Mm-hmm. And I think that if you look at a student handbook and the code of conduct, what many college students don't realize, especially I would say the people who are involved in sexual assault, is that your handbook's a contract. When you enter a college, you say, I'm going to abide by the student handbook. every college has the ability to expel you for not complying with the student handbook. While it's very important for us in this process to create a due process that's fair to both victims and the accused, this idea that you have some kind of special appeals process because it's a sexual assault claim and not a cheating or a theft or any other type of complaint where you get expelled from a college over, I would say that, and this is one of the things that we have to cover with the universities. I've heard loud and clear from universities regarding a safe harbor provision needs to be put in the law regarding sexual assault cases. I know a lot of universities have expressed concern to me in regards to the fact that they will follow their policy, they will expel someone, and that person will sue them and get put back in school.
Right.
And I think in that regard, the courts have largely failed insofar as if someone gets kicked out for cheating, if someone gets kicked out for theft, the courts are not giving this level of scrutiny for other processes in which you expel someone. And it's very important, and that'll certainly be one of the topics we cover in these subcommittees, that if we expect universities to have a robust sexual assault policy that they are going to enforce, they need to know that in following those policies, people are not going to abuse the civil process to try and get a remedy that they shouldn't have. If you attend a university, if you abide by their student handbook, you should be under the same scrutiny you would if you got kicked out for cheating. Mm-hmm. And the reality is that for some reason in this state in particular, the courts have treated it differently in that whereas they would never entertain an appeal if someone went through the entire process and was expelled for theft and cheating, you're out. No court will even entertain that. We are having in particular appellate courts that will say, well, no, we won't entertain a cheating complaint because you didn't comply with the student handbook. But because of sexual assault, we'll take a look at it and give it a different level of scrutiny. Either it is or it isn't. If you go to a college, the handbook lays out what your behavior is supposed to be, and you go through a published process and you're found to be adjudicated and kicked out of that college, you should not have any additional remedies you don't have for other things you're kicked out of in a college. And so one of the things we're going to have to cover on this commission is that safe harbor language, because it is ridiculous that universities, in particular, two of the ones I've spoken to, these are private universities where they've expelled someone for a sexual assault, to then have to go through a court process and someone's given additional rights they really shouldn't even have in that contractual university process is kind of ridiculous.
Yeah, in fact, when students come to us, and I can think of one in particular who came and privacy was really important, so she really didn't want to disclose, but in that I found out that her homework was copied, some project, and I was like, you know what, this might actually be a better route for you to report the assailant on cheating, then, because privacy was important, and so ultimately her goal would be for him to get kicked out, and that was the route she took. So it's kind of an unfortunate thing, but for her that worked. So we also then can't identify that person as exactly a sexual offender. So, but it's easier for survivors, and obviously I'm representing survivors, so I have to go with what their wishes are, but overall I don't want us to have to go through and be like, well, did they steal anything from you, did they cheat from you? Because you know what, we have a better case going this route. We want them to be labeled as sexual offenders on campus because likely they'll do it again if they haven't already, and eventually when survivors feel supported and unfortunately when they realize they aren't alone and that there are multiple victims, usually from one perpetrator, they'll come forward and report to law enforcement. We can finally get these offenders off the streets. So I think if the process was better for survivors and they had a better chance going when reporting sexual violence rather than just going through the cheating route, they would, eventually have a better outcome. But statistically, and I mean, there's different research that's been done that shows that survivors who report to any kind of person, they have worse outcomes than they do if they never tell anyone. So survivors can have a better recovery if they don't tell anyone versus if they tell somebody. And that doesn't sit well with me. So.
Okay. Does anyone else have any questions for these individuals up here right now? Okay. Well, you got one?
Yeah.
Oh, it's actually working now. There you go.
Okay.
All right, you're good.
Is there any sort of with law enforcement now? Some states are going to you have options type of campaign. Does everybody know what that is? It's blind reporting, and there's different levels of it. Is there any such thing on campuses?
Yes, usually they have those confidential advisors on campus where they disclose something. Now, as far as if you're comparing it to the you have options to where it essentially is like a report that there's certain levels where it's a report, it can be investigated but not pursued, or there isn't anything like that other than somebody who's a confidential advisor can sort of hold on to that information, but not really, not officially, like nothing that mirrors the law enforcement campaigns of you have options. So.
Miss Tucker.
Thanks. Hey, Morgan, the question I have is, how are you finding the communication between the different systems on campus? So how much does a victims advocacy program actually know about the disciplinary process, or law enforcement know about that? Like, is there a system where any of these people are communicating about how that works?
So I'm going to give you the lawyer answer and say it depends.
Okay.
It definitely depends on the campus. It does depend on the resource on campus. There are certain, the larger universities have sexual assault response teams on campus where they're kind of meeting together and discussing different issues, which, on the one hand, that can be a really good thing. On the other hand, for certain survivors, if they think that they're going to be talked about in these matters, that it's problematic for privacy purposes. So if those meetings were held to kind of, talk about not the victims, but what are we doing as an institution to communicate better, to provide the resources for survivor, to give them their options, that would be ideal. Not just talking case reviews about what, do we believe this victim or not,
Right.
So.
Norris, you're on.
I know that you guys have mentioned that there's been a lot of inconsistencies, and so I thought it would be a good time to mention that we've had a lot of meetings. The Board of Regents has had a lot of meetings with our campuses, and we've been working very hard to get uniformity across campuses. I can agree that a year ago, there was a lot of inconsistencies, and there still may be to some extent. But some of the things we've done is we've created a uniform policy where we have definitions. So that's a big deal, right? We can all agree on what it means for consent, which will help with the disciplinary process and so on. And so, I appreciate you guys giving us this information, but we are working very hard with our campuses. And in fact, we've received a lot of their institutional policies, and we're going through them now to make sure that they align with our policy, to be sure that there is uniformity and there are no more inconsistencies, and that, survivors are treated like they should be, and making sure they have the resources that they need. So.
And if I could just comment, thank you again, for working so hard and for getting all of these policies to be consistent. I think that having consistent policies is a start. The implementation, application of those policies is a separate issue, because, we're all here in this room and we all can interpret something very, very differently. So I don't know if there can be a way to get everyone from the state in one room and have a training, and everyone here from the same people. This is what this means. This is the place to ask the questions, because everyone can read a document and interpret it in many different ways. And I think that although all the work you guys are doing, I can't imagine how many hours and how much, and resources you guys are doing for it. I think that it will not live the potential that it's meant to, it will not be as potentially beneficial as I'm sure it was meant to be if we don't all get into a room and understand really what it means. Because then you'll start hearing, well, I talked to this one person and this one person said it's applied this way, or this is what it really means. And I think for the survivors that I represent, to be frank, I'm sick of hearing that. I just want to help them. We need to just get to it. And I think that it's a disservice to continue to say, we're gonna keep working. We need to do it now. we need to do it.
Any other questions? I don't see any, so we appreciate your testimony here today. Make sure you fill out your cards. Brandy, you'd like to come up and make a few comments, but thank you for your comments today.
Thank you, and sorry for the technical difficulties.
No problem.